Good afternoon, everyone. We're here to talk today about the hearing process that's going to be implemented by the Industrial Commission starting tomorrow. First, I'd like to thank all the people that have put this together in very short notice, namely Kelly and Carrie, and hopefully we can give you some information that will give you some guidance through a system that none of us really know how it's going to work. This is subject to change, and I'm giving you information based on hearings that no one in the state of Ohio has done yet. This will be similar to unemployment, but it's different. And as we speak, the commission is still meeting on guidelines and procedures and things as to how this will all work. My understanding, there's a meeting today at 3 o'clock, so stay tuned, things could change. So anyway, how long is this going to affect you, and how is it going to affect you is the questions that we have to answer initially. We know that this is going to happen for at least 3 weeks, most likely longer. Most of you, I'm sure, are following the information from the federal government, the state government, and all that. We know this will affect us for 3 weeks. We assume it could be up to 8 weeks and longer, depending on how long the governor and the administration decide, and obviously how this all plays out with the virus. Right now, there will be 2 hearings per room, an hour. That's all. You will be receiving notices that hearings will be continued. And we'll talk about the type of hearings, but just because you have notice of a hearing, do not assume it will be going forward on the issue noticed. There are certain things that are going to be addressed, or types of hearings they will hear. The first is permanent total disability. These hearings will go forward, and they will be difficult to do because, as most of you know, they're very involved, but they are the type of hearing they're anticipating happening. Hearings involving temporary total disability compensation. Once again, it's very difficult when you can't cross-examine someone effectively when they're there, but TT hearings will go forward. Motions to terminate temporary total disability compensation. So if you've had an examination on a maximum medical improvement, and your motion is scheduled, it will go forward. Wage loss hearings will go forward. We don't have a whole lot of those, but those still are planning to go forward. And allowance hearings, those will go forward. So if you're a state fund employer and you have a bureau order that's been objected to, those will be heard, as well as additional allowances. So those are the things that they have specifically stated they will hear. However, there are some things they've said, not specifically, but they've inferred that they will not hear. The first of those is alternative dispute resolution. This involves, a request for MRI, treatment, all those kind of issues will not be heard. Now, this creates a lot of issues, as many of you, I'm sure, are thinking. How does the person get treatment if they need treatment, if it's being contested? There is no answer at the moment, but they will not hear those types of issues. Permanent partial disability, and this is a very big issue. They are not scheduled to be heard. We have probably 10 or 15 notices in this office of hearings that are scheduled. We anticipate, although we do not know for a fact, that these will all be continued and heard at a later date. They do not presently intend to hear these. Now, there will be quite an outcry from the claimants bar and other people, so politically, I can't tell you how that'll work out, but right now, they are not going to be heard. AWW and FWW calculations, those type of things are not supposed to be heard either. Now, once again, that affects compensation and the processing of a claim, so it will slow the system down. There's no doubt about that. What about death claims? A death claim is actually an allowance. There is no specific guidance at this stage provided on whether they would go forward or not. But as many of you know, death claims are usually the most involved type of claim that you have. Oftentimes, especially if it's a non-respiratory case, there are witnesses, there's lots of things that are involved. Theoretically, right now, they can go forward as an allowance, but that's something that you should discuss with your representative, and you may want to request a continuance. We've been told that continuances will be freely granted when there is an issue. I will tell you, as a matter of experience, recently, continuances are being denied for a lot of different reasons. Court reporter, they've denied requests for court reporters already. We refiled a request because we wanted to be able to cross-examine the claimant in a psych claim. That has been denied. There are other things that are being denied, so I am not sure I would rely on the statements that are coming out right now that continuances will be freely granted. How this will play out in the long run, I don't know. How do you do this? I mean, that's the ultimate question. If you want to have a phone hearing, which is the only option you have right now, there's a process that's been set up. The first thing you do is you go to ICON, and the site's there for you. And this is important, though. You must upload a document before you can do anything else. The document that you upload, it has to have the claimant's name, claim number, the date of the hearing, who's representing you, either the attorney or the TPA, contact number for yourself, the representative, and any other witnesses that you plan on having present at that hearing. So this must be uploaded first. That's the first thing you need to do. After you've done that, you must go back to the claim uploading document and type in, there's a box there, the claim number of the numbers for the call-in, and then the Industrial Commission will call you. The other practical part of this is you need to then upload that information to the active folder for the hearing. So remember, the first thing we know we have to do is upload a document with basic claim information. I suggest you prepare a template with the material that I've listed there on it, so you have it. Second, you got to go in and add physically the phone numbers to the box. Third, go back and make sure that's in the claim folder. I am sure that there's going to be issues with this. I can tell you we've done it on several of them already for hearings tomorrow, and with some consternation we've been able to get it done. So that's what you need to do. If you have someone that's representing you, you need to make sure that either you give them proxy or an R1 and get that in quickly. If you have an employer that wants to come, you need to give the right phone number, all of those things. What we are telling people to do at this stage is call the witnesses or the employer or whoever you represent first and have them on the phone so they're available when the Industrial Commission calls you. I know offices have different ideas and procedures on who they want in their offices currently, so you'll have to look at that on a case-by-case basis. There are a lot of problems that we have with this system and concerns, and the reality is we're just going to have to deal with them. The first is when you're cross-examining someone, it's important to evaluate and look at their demeanor and determine whether they're telling the truth. That's very difficult over the phone. Some of you probably dealt with the Commission's failed attempt to do video hearings a few years ago and saw these problems firsthand, but that's going to be a very big problem. The second problem is like any conference call. We all tend to talk over one another, and depending on the hearing officer, that will be very difficult. The hearing officer is going to need to run a tight hearing, and all of us as witnesses, employers, attorneys, TPAs, we need to be respectful and listen to one another. And as all of you know, that sometimes is difficult in these types of hearings, especially with an unrepresented claimant. A court reporter, it's very unclear how that's going to work. Where does a court reporter go? As I said, a continuance was just denied with a court reporter. Can the court reporter get into the commission? Will they allow them in there? Will they be in the office with you? There's lots of things that are unclear about that, but if it's a credibility issue and you need a court reporter, work with your representative, and we're going to have to figure out a way to do that. As I said, as soon as we get some guidance from the commission, we'll add it to the information on our website and let you know. Plain video evidence, that's difficult. It's hard enough sometimes to have the hearing officers really review it, but maybe you want to review the tape with the claimant. That's going to be difficult. Same if you have surveillance evidence and you want to do that. But upload it like you always do, and you're just going to have to ask the hearing officer review it. The other issue that I don't have on the slide here, but it's come up, is what about interpreters? And I don't have a real good answer for that right now. It's going to be difficult if the person doesn't speak English and you have to have an interpreter. I don't know whether the interpreter will be at the commission, whether they will be allowed to go to the claimant's lawyer's office, or any of those things. And obviously one of the concerns we all have is without being present, you don't know what the witness or the claimant is being told or not told by his or her lawyer. And I'm sure they could have the same concern if I have the employer sit in the room here. But it just creates potential problems. So what are the suggestions? What do we do to get through the next 3 weeks or longer? First, I suggest you have your clients or witnesses on the phone with you when the Industrial Commission calls. As I said, some of you may choose to have the clients in your office or the witnesses in your office. Others, offices are working remotely. Some people in our office are working remotely, so it's a little more problematic, plus the whole issue of exposure. We don't want to have people exposed. So you need to look at your own situation, and I suggest you talk to your representative about that now. It's really important. You shouldn't do this anyway, but do not allow the other side, either the union rep or the lawyer, to lead the witness or to testify for their client. You have no control of what's being said when you can't read the claimant when that happens. So it's imperative that you make them stick to the facts in these cases. If you don't do that, we're not going to get a fair hearing. Also, whether you are a law firm or an individual, I think what should happen is you should assign one attorney to one room. There will be 2 hearings in that room the hour. The problem often comes up that is if someone double books this and they have an attorney in room 3, another attorney in room 4, and they're calling us, if they call and they get a busy signal or you're on the phone in the other hearing, this creates lots of issues. And I don't think it makes sense. So I think I would suggest that you ask your representatives, or I know what we're doing is we're going to have one attorney assigned to that room, even if there are multiple hearings in the room. It just makes sense. You also should be aware that we don't know the answer to this question, but it doesn't mean that you have a Toledo hearing that you will necessarily have a Toledo hearing officer. With the way this is working, they could have a hearing officer call from Columbus, Lima, anywhere in the state of Ohio. And because of some of the scheduling problems, that may happen. We haven't been told that's going to happen, but I don't think you should believe that just because it's a hearing in Toledo that you'll necessarily have one of the Toledo hearing officers. I think another thing that needs to be stated, and this could be an issue, if a hearing's going forward and your client is not getting a fair shake because of the way the hearing is being conducted, I strongly believe that you should request continuance, even if it's in the middle of the hearing, and talk about due process and demand that the hearing officer state your request for continuance. Most likely, those requests will be denied, but you are building a record. They are taking away various rights for good reason. We have a crisis, no question, but your job is to protect your client and your position. So if the hearing is unfair and the fact that you can't do things that you could do normally, you need to preserve those for appeal and future consideration. The other thing that you need to do, this should be done anyway, you need to make sure the materials are timely filed, especially now, and have image dates and page dates available, because if you don't, the hearing officers are going to be very difficult. They are in a difficult position too. Their job is to evaluate the claim and the people, so you need to make their job easier. And I really strongly suggest that as you're reviewing this file that you have those notations there. Most people do that now as a matter of course, but it's really critical that you do it in this case. Finally, and I guess this is just common sense, utilize your computer and icon during your presentation. You can see what's going on. You can reference the documents. Some representatives are more accustomed to using paper in the presentation versus their computer, but clearly you can do both here. So have the file up, be willing to interchange or discuss with the hearing officer various documents so we make sure that the hearing officer knows where things are, because that could be a very big problem in these claims. Those are the suggestions that I have for you, and if you'd like, I'll answer any questions that I can. As I said, stay tuned. A lot of this may change. I appreciate you all tuning in today to see what we know, and as I said, Bugbee and Conkle will keep you advised of all things as they happen. It's a change. It's a tough time for all of us, and we're all trying to figure out what's best to do to protect everyone's safety and to keep the system going so employers represented and claimants receive the benefits that they're entitled to. I hope all of you are safe, and I wish the best to all of you as we deal with the evolving crisis. Thank you very much.